Court of Appeals is now in session. God save the state of Texas and this honorable court.
Thank you. Please be seated.
First, I want to thank University of Texas Law School again for hosting our homeless court, and we're pleasure to have you here with us. We've got a number of cases on the docket, so we'll get right to it. Move this aside so I can see you folks. First, we've combined two cases for oral argument, State of Texas versus City of Austin, State of Texas versus City of San Marcos. Courts set aside 30 minutes to be split, 30 minutes for the state and 15 minutes each for each of the cities. Attorneys ready? You may proceed.
Good morning, Mr. Chief Justice, and may it please the court. My name is Cory Scanlon for Appellant, the state of Texas. The cities directly violated state statute by adopting ordinances that foreclose prosecution for criminal offenses. In doing so, they violated the sovereignty of the state and usurped the legislature's authority to establish its criminal law. The ordinances are not discretionary deprioritization measures. Inherent in the idea of prosecutors and law enforcement being able to establish their charging priorities is the ability of those authorities to pursue low-level offenses as higher-level crimes are resolved. But these ordinances remove the possibility of prosecution for those offenses, tie the hands of police officers by prohibiting arrests for those offenses, and have the practical effect of nullifying Texas criminal statutes within the city limits. These ordinances categorically restrict rather than uphold the discretion of law enforcement, and city officials should be enjoined from enforcing them. I'm going to cover three things today. First, how the ordinances are preempted. Second, how standing and immunity pose no barrier to granting the temporary injunction. And third, that Texas has met all of the required elements to establish.
Before you do that, let me just ask so prosecutorial discretion, familiar with, prosecutor decides whether to press charges or not. Police officers also have discretion, decide whether to charge somebody or to give them a warning, or is that only when I'm stopped in traffic that they have that kind of discretion?
No, Mr. Chief Justice. I think the line of cases that my friends on the other side have pointed to are cases in which private litigants have attempted to sue police authorities for failing to exercise their discretion. And we certainly wouldn't disagree with that idea. But in this case, the issue is whether they have the discretion to make an arrest in the first instance.
Would the state have the authority, if the state wanted to take away all discretion and say you must, like for murder or something, say, you must prosecute all murder charges? Like, is that something the state would have the power to do?
I think the state would have the power to do what they've done, something similar here, where the DA is not going to adopt any policy where they're not going to fully enforce the murder laws.
So this isn't like Castle Rock where you've got a private party trying to compel enforcement. This is the state.
That's correct, Your Honor. Starting with the text of this provision, it applies to the governing body of a municipality or a municipal police department. It says that they may not adopt a policy under which they will not fully enforce laws relating to drugs. Now, contrast that with the language in the ordinances and the provisions in the ordinances. By their own admission, these are ordinances to, quote, eliminate low-level marijuana enforcement, end quote.
So under Texas law, if I understand your position, the police, city officials, they have discretion whether to prosecute, but the ordinance takes away that discretion to be able to prosecute these low-level offenses, basically, right?
That's correct, Your Honor. And I just clarify that the ability to exercise that discretion in the first instance is what's being taken away. And the ability to exercise that discretion on a case-by-case basis is appropriate. But what the cities have done here is issued a blanket policy that certain offenses they're not even arrestable. You can't arrest someone for possession of marijuana. The other point is that there's no discretion for law enforcement or prosecutors to charge a Class C paraphernalia offense in lieu of the Class A or B offenses, and that officers will be disciplined under these ordinances if they don't comply. In San Marcos, there's another limitation on officer discretion by saying if you have the odor of marijuana, you can't institute a probable cause search for that. So when analyzed side by side, the court can easily conclude that the legislature has preempted ordinances like those here with unmistakable clarity.
Does the fully, go ahead.
No, you go ahead.
Does the fully enforce language prohibit what you were just talking about, charging, for example, a Class C paraphernalia charge for what would normally be a Class A possession charge?
I think what I was getting at, Your Honor, was that they have to have the discretion to be able to use that in lieu of a more serious charge if that's what the prosecutor wants to do. The fully enforced language isn't really a barrier for the temporary injunction because the language read in its full context is not a bare mandate to fully enforce the drug laws. It's that the cities cannot adopt a policy whereby they are not going to fully enforce the drug laws.
What if the situation were a little different? I mean, in reading the briefs, there was a lot of explanation about how hemp products are not being tested anymore for misdemeanor amounts by law enforcement. And so what if it was just the prosecutor, in this case the county attorney, sending a memo to the police officer saying, look guys, I'm not prosecuting these anymore because I can't get tests done. Would that be afoul of the statute?
It's likely that would if it was a blanket policy that said these offenses are never going to be prosecuted. When we questioned the city authorities in both cities, they both admitted that there are different ways to prove these offenses. There's not necessarily going to be testing in every case. And when you look at the language of the ordinance compared with the language of the statute side by side, the legislature's test for unmistakable clarity is met. I'd further add that it's the intent of the legislature to preempt. It doesn't mean that the language has to be crystal clear for preemption to apply. The cities below had argued that you have to basically establish preemption in all applications, which is not a correct recitation of the test.
And so seizing the product is not fully enforcing in the state's view?
That is one measure of enforcement, but if you have a police officer, they have the tools in the toolbox for enforcement. That would include arrest. And saying that you're still enforcing the law because you can seize it, or you can still make an arrest because of these exceptions for a felony narcotics or a felony, violent felony crime, is a little bit like saying, in our city, we're not going to issue anybody a speeding ticket unless they happen to run somebody over. So the authorities have to have, like I said, all of the tools in their tool belt. They also said that they can't plea bargain, or, well, this is what the city of Austin specifically said, that they wouldn't be able to plea bargain or offer diversion, but they can't do that under the ordinance for these crimes either, because there's no defendant to plea bargain with if you don't arrest them. The city of San Marcos has kind of addressed this by saying, well, the ordinance or the statute doesn't say that local ordinances are expressly preempted. That language is not a requirement to find preemption. I'd cite the court to the Laredo Merchants, the city of Beaumont v. Vahl case, and the BCCA appeals group in which that language wasn't necessary to find preemption. Turning kind of to standing, the city hasn't really grappled, and standing is only argued in the Austin case. San Marcos hadn't brought it up. In Ray State, that we cited in our brief, standing is established at the temporary injunction stage for violations of state law by local authorities. That automatically results in irreparable harm to the state, and the state has a justiciable interest in its political subdivision's compliance with Texas law.
Could we talk a bit about who the proper parties should be to this case? So I know that the ordinance has already been approved you can't really unapprove an ordinance, right? Or how does that work within the framework of what type of relief can be obtained against city officials?
Sure, Justice Ferris. So all of the defendants to this case are proper parties through the judgment that we're seeking. We are asking to enjoin all of the city officials from any further acts of implementation and enforcement of the ordinances. The city manager oversees the chief of police, so they have control over the chief of police. The city councils can fire the city manager at will with some limitations under both cities' charter. The Declaratory Judgment Act says that the city has to be sued
Sure.
to challenge the validity of the ordinance. So we've got an entitlement to injunctive relief on one side and entitlement to a declaratory judgment on the other side.
So your relief is going to be declare the ordinance, or whatever in each case, to be preempted and to enjoin or the officers from enforcing it or following such a policy.
Yes, Your Honor, and there's further acts of implementation that we would ask to enjoin. Both police departments have passed specific policies. We'd ask the court to enjoin any other policies or procedures that have been passed under these ordinances. I think that the declaratory judgment also makes this kind of redressable if the ordinances are declared void.
So what's the difference? Probably the police officers know what their bosses want them to do. We tell the bosses, stop doing that, we declare the statute, but if the individual officers want to choose in their discretion not to prosecute anybody for minor drug or marijuana offenses, they'll keep on doing whatever they want to do.
It's possible, but the real harm here is to the sovereignty of the state. So clarifying the policy, what the state of the law is. And we also had the chief of San Marcos Police Department testify that his officers were not making arrests that they otherwise would. I would cite to pages 52 through 53 of the second volume of the reporter's record.
Thank you.
And I also think that just kind of turning to San Marcos's argument about they're not proper parties to the injunction because they did not adopt a policy, I think that's really not much more than a magic words defense. The chief of police in San Marcos was apparently instructed that as long as he didn't use the label policy in issuing his memorandum, it would be rendered legal. It's unclear exactly what the city means in making this argument. It's either that the word policy doesn't include an ordinance, or it's that none of the officers or the city council committed an act of adoption. Either way, that argument fails. An ordinance is obviously a more specific item of legislation that can be included within the meaning of a policy, and the record undermines the city's argument about adoption. At Volume 3 of the reporter's record, pages 46 through 49, the resolution that was signed by the mayor stated that it will be effective immediately upon adoption and that it was considered, approved, and adopted right above the mayor's signature.
Does the city have discretion when the citizens have an initiative that leads to a vote and they vote for something?
I think they do, Your Honor. We saw that with the city of Bastrop, the letter that I filed earlier this week. It's clear under both cities' charters, under the Texas Constitution, that if a provision is going to run afoul of the Constitution, the city council has the authority to reject that because, again, if it violates the Constitution, it can't be given any practical effect.
Well, but I guess they're going to get sued either way, right? If they.
I
If
don't
they
know
do or
that
they don't.
for
Okay.
certain, Your Honor. It's definitely a possibility. We've seen lawsuits on this issue. There's multiple cases working their ways through the courts right now. So I don't think that lawsuit would go anywhere because I think under Glass v. Smith, the Supreme Court has said that the legislature may withdraw certain subject matters from the field of the initiative, in which case they wouldn't be penalized for doing what the city of Bastrop did. So although the courts have certainly reflected a lot of respect for the initiative, in such a case as this, where the statutory prohibition by the legislature on its home rule cities is so clear, I wouldn't think that lawsuit would go very far. I've been wrong before, but San Marcos, I think the issue about kind of relying on the voters and saying there's nothing we could do, if that's taken to extreme, it's kind of an absurd result. A court cannot declare an ordinance unconstitutional when it directly conflicts with state law anytime it receives voter approval as an initiative. That would kind of be the rule here. There's no support in the law for that. San Marcos, this issue kind of also conflates the voters' right to have an election called, which in this case, the court doesn't have to decide whether that could have happened or not, with the implementation and enforcement of the ordinance, which is all we're asking for here.
Aren't we, I mean, do we have a danger here that we're wading into policy decisions by a government body where the citizens themselves are recognizing a lack of police protection and wanting police officers to stop violent crime, things of that nature, and use those funds for that rather than misdemeanor marijuana enforcement? I mean, where does the line there of local control versus state intervention?
To answer the question, Your Honor, I'd say no. We're simply asking the court to apply the preemption statute that we've cited, Texas Local Government Code, Section 370.003. But the issue about where the line is to be drawn, I think, could maybe be more challenging in a future case. But in this case, the court can say with certainty that an authority is not fully enforcing the drug laws, that they're not even allowed to arrest them. So to the extent there's challenges regarding allocation of resources or priorities or arrest decisions, that's really not what this case is about at bottom, as I kind of mentioned at the.
What do we do with the language in Castle Rock that, fully enforced can't mean fully enforced?
I think, Your Honor, like I mentioned, the fully enforced language doesn't have to really be specifically defined by the court. The prohibition here is adopting a policy under which the entity will not fully enforce. So to the extent we agree that there's never going to be 100% enforcement, maybe in some places, that really kind of just means that the public's expectation of full enforcement has to be there. That's represented in our laws. Texas Code of Criminal Procedure, Article 2.13 says officers shall make an arrest without a warrant in cases in which they're authorized. So I think you start with the presumption, and the public has to have the presumption that they're not going to be able to rely on an officer's discretion to be able to commit a crime. I think that's all that the court really needs to say on that issue.
But isn't there already discretion, though, in this context, given that you can't tell when you see a plant if it's legal hemp or if it's marijuana, because the definition is the THC percentage, and you don't know that until you test the plant. So don't we already have a lot of officers who would see marijuana flower potentially that could be hemp and just go, yeah, I'm not touching this?
If that were to happen on a case-by-case basis, I don't think this ordinance would reach that, Your Honor. The challenges with resources, like I said, would have to be addressed on a case-by-case basis.
So the bottom line is it's really the prohibition contained in the ordinance for enforcement. It's not a matter of do they have discretion or not. It's the prohibition of full enforcement.
Yes, Your Honor. I think that's correct. I want to talk about the constitutional challenges that the City of Austin has raised. They've raised separation of powers and vagueness challenge, due process vagueness challenge. The we start, I think, with the presumption that statutes are constitutional, and constitutional avoidance doctrine should kind of render those issues moot. I think that applies here, and also I'd add that the state doesn't have a burden up front to prove that a statute is constitutional. The separation of powers issue, there's really three reasons that that argument fails. First, cities are not a branch of the state government under City of Fort Worth v. Zimlick. The plain text of the separation of powers provision allows for some interplay between the branches when it is, quote, expressly herein permitted.
Would you have a separation of powers problem in the hypothetical I posed earlier, that the prosecutors had told the city, we're not prosecuting anymore? Because
No, Your Honor. This would be covered under the preemption statute because a prosecutor is one of the entities, and the separation of powers problem says if other provisions in the Constitution allow that interference with discretion, if you want to call it that, that's okay. So the home rule provision is kind of what would govern that. And it says, no charter or any ordinance passed under said charter shall contain any provision inconsistent with the Constitution of the state or the general laws enacted by the legislature of the state. The third point on separation of powers is that it's really the ordinance that interferes with discretion and not the preemption statute. The ordinance allows the authorities full discretion. So by taking away the tools of arrest and citation, you don't even have defendants you can really bring a full case against. That severely interferes with prosecutorial discretion. On the vagueness point, the city is not a person or citizen who can challenge statutes alleged to infringe on Bill of Rights protections. In other words, courts have long held that cities cannot bring a due process challenge against the state, and because the vagueness doctrine protects individual and not city rights, the city's vagueness challenge should be refused. Unless the court has any further questions.
Thank you, Mr. Scanlon.
Thank you. I'll see you on rebuttal.
Good morning, Mr. Chief Justice, and may it please the court. Section 370.003 of the Texas Local Government Code, which purports to prohibit certain entities from adopting a policy under which those entities will not fully enforce all laws relating to drugs, is vague to the point of being no rule at all. But given
Before we get started on that, do you agree with your opposing counsel's characterization of a vagueness allegation being a subset of due process, and that cities can't assert due process rights as against the state?
Not exactly, Justice Ferris. So the U.S. Supreme Court in United States versus Davis, which is a 2019 case, said that the vagueness doctrine, quote, rests on the twin constitutional pillars of due process and separation of powers. And again, in Sessions versus DeMaya, 2018 U.S. Supreme Court case, also said that the vagueness doctrine is a corollary of the separation of powers, requiring that Congress or the legislature, rather than the executive or judiciary, define what conduct is sanctionable and not, or what is not. And so, in other words, the vagueness doctrine comes out of both due process and separation of powers.
But if we didn't if we didn't agree with your line of argument on separation of powers, then the only prong we would have left would be due process.
I'm not sure I follow Justice Ferris. So there's
Yeah.
kind of two
Sure.
and maybe more than two separation of powers concerns. So one is a separation of powers challenge to the legislature purporting to control how prosecutors prosecute. And then there's also the vagueness of the statute itself, which comes out of both due process and separation of powers.
Mhm.
So I'm not sure I'm answering your question exactly.
No, I think that's it. I was just saying, if for instance, if we don't agree with you on the separation of powers arguments, would the only hook for vagueness be due process? And so would we need to rely on due process?
Right, so I think if you could disagree with me that the statute improperly interferes with prosecutorial discretion, but still agree with me that the law is so vague that it presents a separation of powers problem. Because it is in effect asking the court to write the law for the legislature. So I'm here to advocate for I just said that this law is unconstitutionally vague, but I would like to advocate for a limiting construction under which it should be properly understood to mean that regulated entities cannot adopt policies of blanket non-enforcement of misdemeanor marijuana possession. Or in other words, that some enforcement mechanism must remain for misdemeanor marijuana possession. And seizure is a form of enforcement. So enforce means compel compliance with the law. And by seizing suspected marijuana, that is compelling compliance and stopping the possession of the suspected illegal marijuana. So seizure is enforcement. And Austin Police Assistant Chief Eric Fitzgerald testified at the temporary injunction hearing in this case that enforcement mechanisms run the gamut from police presence alone all the way through custodial arrest.
Well, but that's, the vagueness rule applies only if you can imagine the circumstances where it would be vague, but if you certainly knew it applied to you, and just reading, that they can't make arrests or citations, they certainly knew what they were doing violated that. I mean, that's perfectly clear.
I disagree, Chief Justice Brister, and here's why. And I think it got to the court's colloquies with my friend on the other side about whether the law prohibits an officer from exercising discretion or not. Because my friend on the other side says this law does not prevent individual officers from deciding whether to arrest or cite for misdemeanor marijuana possession. But the law, the 370.003, could equally be interpreted to require arrest or citation in all instances of misdemeanor marijuana possession with probable cause. And so that is vague.
Well, but the statute just says cities can't have such a policy. It's not directed at police officers.
But if, let's say the city has a policy under which it will leave it to the individual officers to decide whether to arrest or cite, that could be interpreted as a policy under which the entity will not.
But isn't that what you had before the ordinance was passed? Like there was that discretion and then the ordinance took away discretion in some instances to use certain tools?
I suppose so, but then the question still remains, does 370.003 prevent that limitation and cabining of discretion? Particularly when officers are still enforcing through seizure. Going back to 370.003 and whether it is vague as applied to the city, back to the Chief Justice's question, another, I think, way to get at the vagueness as applied to the city is that the ordinance also prohibits using city resources for testing misdemeanor amounts of marijuana for THC concentration. And the state is seeking to invalidate all of the ordinance. And so the state is saying even those kind of funding decisions are preempted by 370.003. And then what's to prevent the state from saying, well, anytime the city council adopts a budget under which 100% of its budget is not devoted to drug enforcement, that is council adopting a policy under which it will not fully enforce.
Well, again, that's not the case in front of us, and then would have a vagueness problem. But vagueness, when it says you can't have a deal that says no citation or arrest for misdemeanor, That's not vague in our case.
But I think it's telling that the state says, oh, don't read this literally. We can't actually rely on the words on the page. Fully enforced doesn't mean fully enforced, because obviously that would not work. So I think we are still left with this vagueness problem in the statute. And then as a preemption matter too, even just setting aside the vagueness issue, as a matter of preemption, under City of Beaumont versus Vahl, a local law and a general law are not to be held repugnant to one another if any other reasonable construction can be reached. So I think, again, a reasonable construction of 370.003 is to prevent blanket non-enforcement of offenses, and since the Austin ordinance does not do that, they can coexist. And I wanted to touch too on a little bit of the context here, which Justice Field alluded to, which is that in 2019, Texas legalized hemp and changed the definition of illegal marijuana to exclude legal hemp. And definitionally, legal hemp is the plant, the cannabis plant, and any part of that plant with a THC concentration of not more than 3%, 0.3%. And so the only way to know for sure whether a substance is legal hemp or illegal marijuana is through testing. Can't be done through sight or smell alone. And so this ordinance grew out of that kind of legal landscape. And I wanted to touch too on the kind of citizen-initiated ordinance process. I strenuously disagree with the state that the city is able to just look at a petition and say, that's not gonna work, and toss it out the window. It has to, once it has the requisite signatures on the petition, it has to call the election, and it has to canvass the vote, and I think it would be mandamusable violation of the elections code not to canvass the vote, and which.
So even if you had something just blatantly unconstitutional, like, there's an initiative to ban women from voting, the city still has to go through the process and approve that?
Yes, it would not have to enforce it, but yes, it would need to have the vote and canvass the vote. Hopefully it doesn't pass, but.
Right, but do they have to pass the ordinance? That's the question. I mean, they have to canvass the vote, I understand that, but then the ordinance still has to be approved by the city council. Do they have to do that?
No, Justice Ferris, so the canvassing is the approval of the ordinance.
Okay.
And I may have just called you Justice Ferris, may I?
That's okay. That's all right.
So, and that's another curiosity about this law is it doesn't say that any contrary ordinance is unenforceable or preempted. It just says cities can't adopt a policy, but it doesn't say what happens specifically.
So the city of Bastrop was just way out of line, like they didn't have, can you explain why what city of Bastrop did was wrong?
Yes, I mean, the city of Bastrop, I think, I'm speculating here, but I think they thought they had a 100% likelihood of being sued by the state if they canvassed the vote, and maybe a less than 100% chance of being sued if they didn't, and opted with the latter. So I guess with my remaining time, I'd like to touch briefly on some of the requested relief that the state asked for, because it goes, I think, well beyond what is permissible. So for example, one of the things the state asked for is a temporary and permanent injunction ordering the city defendants to repeal its own ordinance. And that's just not an available form of relief. The state could, if the state's right that it's preempted, it could get declaratory relief that the ordinance is unenforceable, enjoin enforcement of it, get relief that it's void, but to reach out and require the city of Austin to repeal its ordinance, that is, again, a separation of powers problem. And the Pigeon versus Turner case speaks to that. And then its other requested relief, so it again, doesn't simply request that the ordinance and corresponding APD policy be adjoined, but another component of relief it requested in its petition was an ordering the city of Austin defendants to fully enforce the drug laws in Chapter 481, which what does that even mean? And then that runs headlong into the problem kind of described in the enforcement priorities case of not having standing to order a body to effectuate more arrests.
So would you agree that the state law in question, if, assuming for a minute that it's not vague, the state law imposes or prohibits imposing a bar on full enforcement, but it does not mandate full enforcement, right?
I guess I'm stuck, Justice Ferris, because I think it is vague, because I don't think you can tell whether it prohibits discretion on the part of officers to arrest or cite.
Okay.
And I think the state is saying conveniently and trying to appear reasonable, saying that it's not, but I don't think you can get that from statute.
But what the Texas Constitution says is no ordinance passed under city charter shall contain any provision inconsistent with the Constitution of the state or the general laws enacted by the legislature. It doesn't say they can't be enforced. It says they can't have them. No charter shall contain any provision inconsistent with state law. Now, how are you going to comply with that constitutional without ordering repeal?
I think that if a law is deemed unconstitutional, it's a nullity. It's as if it doesn't exist. So I think that's the way to square those two concepts. But I still maintain that ordering a legislative body to repeal a law, if it were the state of Texas and someone told us.
But then you would be it says you can't have an ordinance that contains a inconsistent provision. And so, in fact, you can.
I see I'm out of time, but
No,
yeah.
I'm puzzled. Your position itself would violate. Your solution that you can't repeal it would violate that clause because it allows the city to keep a provision that's inconsistent with state law.
And I go back to a void law, an unconstitutional law is in effect no law. So I guess it's maybe.
So it gets a little red flag on Westlaw, basically, right?
Thank you.
Thank you, Ms. Hale. Ms. Smith?
Morning, Chief Justice, and may it please the court. I want to start maybe with the question you posed, Justice Ferris, about whether or not this statutory provision, section 370.003 of the Texas Local Government Code, talks about prohibition. And I think that it does. It talks about you may not adopt a policy that prohibits full enforcement. This statute is about prohibition. It's not about affirmative obligation or affirmative requirement. I think that's really important when we're talking about relief that's sought to fully enforce the drug laws of the state. That goes well beyond what the statute requires. And so I do want to take a bit and do a bit of a reset, because I know we've kind of gotten into the weeds about what certain enforcement measures look like, but I want to make clear that this case is not about marijuana, but it's about the questions before the court that center on immunity and municipal governance. So I know your honors are all very familiar with governmental immunity, so I won't get into a primer, plus I don't have a whole lot of time today. But I think that it's important to remember that we start with immunity when we're talking about government officers and governmental entities. Waivers are exceptions, immunity is the rule. And in order to have waiver, you have to have that validity to what you're challenging. So let's say you have a concert ticket and it's to your favorite band, you have a ticket for Thursday night, you try to use it on Friday, you can't use it, right?
Well, can the city be sued to declare an ordinance preempted?
The city can under the UDJA,
And then
yes.
UDGA, right.
Yes, but even then, you still have to have a valid challenge to the ordinance in order to survive a jurisdictional challenge.
Right.
And that, we don't have that here, right? This is like if we use a Thursday ticket on Friday. There is no valid ticket for entry here. And so we have two buckets. We have bucket one, we're talking about a city being sued for preemption. We have bucket two, talking about ultra vires acts by each of these government officials, right? And so I said bucket two, but I'm gonna start with bucket two as bucket one. And so I wanna go back to section 370.03 again and what it says. It enumerates certain entities or certain officials, you know, the governing body, the city council here, commissioners, court of a county, sheriff, et cetera. And it says then what they may not do. They may not adopt a policy. What can they not adopt a policy to do? They cannot adopt a policy under which the drug laws of the state will not, and also under federal law, will not be fully enforced. And I think that's important because we've talked a little bit about this morning, you know, the state law, but I think when we took with Justice Field, I think he brought up the change with the Farm Bill and the legal definition of hemp. We also have House Bill 1325 that was passed in 2023. And again, I think that what the citizens here have voted for, and I want to be very clear, the citizens are who adopted this. It's not the city council, it's not the mayor, it's not the police chief, it's the citizens of the city of San Marcos who adopted this.
But the state can't just randomly pick a citizen and sue them, right, to obtain relief.
No, but I think
Right.
that the problem we have here is the state filed a lawsuit that doesn't cover the realities that exist. So here we have a citizen initiative that was, the citizens did what they're supposed to do under the city charter. They went and got their petition, they got all the requisite signatures. And in fact, I know that Your Honor also posed earlier whether or not the city had discretion and whether or not to hold the election and to certify the results. They absolutely have to hold the election and certify the results. Glass v. Smith, that's been on the books for, you know, well over half a century, says this. But even last year in N. Ray Rogers, the court again said that.
So I'm sorry to interrupt you. Your position is 370.003 says governing body, commissioners, court, sheriff, police, county attorney, district attorney, criminal court may not adopt a policy. Aha, we found a loophole. The people can adopt a policy. That's your argument.
It's not a loophole, Your Honor, I think, but it might be, as in the state might be pointing out that it thinks there's a gap in the statute. But, and as much as I respect each and every one of you, the way we fix gaps is not here in this courtroom, it's down at the Capitol building. So to the extent that the state thinks that there's a gap and that there are other ways that this should be solved, and we know the legislature knows how to do something that is not so specifically spelled out and enumerated because they have in other statutes in the Texas Labor Code. It's Texas Labor Code section 62.0515.
Where in the record do we have the, I understand you got the canvas is where you say this is the official count, the ordinance passes, it doesn't pass it. Where's the provision that says then it becomes automatically an ordinance? Is that in the record?
It is in the record, and I should have had the page in front of me.
That's all right. You can.
But it's in the city charter sections. It's 6.10. It says, if a majority of the legal votes cast is in favor of an initiated ordinance, it shall be effective as an ordinance of the city when the result of the election is declared. And so I
So
gave you
somebody
all,
still has to declare the result, right?
but declaring the results is declaring the results of everything that was on the ballot, right? It's the proposition that's on the ballot that results in this enforcement ordinance. Because there's really two ordinances we're talking about. The enforcement ordinance, capital O ordinance that talks about marijuana enforcement, and then there's the canvassing ordinance that just purely is a tabulation certification. Yep, this many votes for, this many votes against. And that's really all that ordinance is. And I know that my friend here, Mr. Scanlon, talked about the city adopting and approving the capital O ordinance, the enforcement ordinance, but that's not what it was. If you look at tab A of the exhibit binders I presented, you can see the full text of the ordinance, and it makes clear when you have all of the context that what the city council and the mayor approved was just, here are the votes.
Well, so
this
why
many-
do we have this language, be it ordained by the city council, then, like, I mean, if nothing more was required of the city officials, why do we even need that language?
Well, because they have a ministerial obligation to canvass and certify the votes.
So they are doing something.
They are carrying out their ministerial obligation to certify the votes, but they are not, so under the city charter as well, when they get a signed petition, the city council has two options. Option one is that they can say, we're gonna vote on this and decide whether or not this is an ordinance that the city council itself is adopting.
Right.
City council didn't want to adopt the ordinance, in fact, affirmatively did not do so. The only other option is saying, well, the people want this, so we have to put it on the ballot and let them decide. And that's exactly what happened in this case. So there was no affirmative act of adopting here by the city council. All it was them carrying out a ministerial obligation. And when you asked if they had an obligation, they did. And in fact, if they hadn't done that, that had probably been ultra vires, right? Because they have a ministerial obligation to certify the election. And that's a pretty good lawsuit, I'll tell you that. But they didn't do that here, so.
But that argument goes fully to the ultra virus action that doesn't dispose of the immunity with the UDGA and the validity of an ordinance. How do you get there?
Absolutely. So, yes, I mean, so ultra vires action, easy. None of these people took any action to adopt a policy. And I also have Chief Standard's full memo as a tab B for you all, so you can see that there is no policy that was adopted. It was purely a communication of, here's what the folks did here in San Marcos, so their officers are aware. And so as far as the preemption here and the UDJA, Justice Fields, there's also not an inconsistency here because, contrary to what my colleague said, there's not necessarily magic words that it has to look like, you know, this is expressly preempted. But that often is what it looks like. And we know that because we have clear examples from the Texas legislature that have showed us what it looks like when the legislature does want to clearly and unmistakably preempt a field. So we have, like I said, Texas Natural Resources Code, section 81.0523, that says that the authority of a municipality or other political subdivision to regulate an oil and gas operation is expressly preempted. That's a good example of unmistakable clarity. And I know that my friend here, Mr. Scanlon, also pointed to the City of Laredo versus Laredo Merchants case, and I think that's another good example because the City of Laredo is, you know, we're all familiar with the shopping bag bans here, but the Texas legislature went back and passed the Solid Waste Disposal Act that does have language and that says a local government or other political subdivision may not adopt certain ordinances. And that's in chapter 361 of the Texas Health and Safety Code. And so that's another example of where they're clearly trying to have broadly prohibit a city government from adopting certain ordinances. Again, this statute looks different, and it looks different for a reason because it is different and it should be applied differently. And so when we talk about as well the language of fully enforce, right? Fully enforce means, like Ms. Vahl said, to stop, prevent criminal activity. It does not mean arrest. It does not mean citation. When Chief Standridge...
But it could include those things, right? I mean, if I want to fully enforce the policy that my daughter will do her homework, which sometimes happens and sometimes doesn't, but mostly happens. If I am saying like, okay, I will never take away your phone in support of carrying out this policy, you know, is it really fully enforcing when you're taking a tool away that state law says you should have? I mean, full means complete, right? 100%. And so isn't it at least conceptually possible that this ordinance is taking away the capacity for full enforcement, even if it's still leaving some discretion in play?
I think there's an ordinance that could do that. I don't think it's this ordinance. And the reason why I say that is because not only does it still allow seizure and destruction, which are methods to prevent and stop criminal activity, but it also doesn't remove citation and arrest in all circumstances. So if it's in the during commencement of another felony, narcotics offense, or there are certain instances where you can still cite and arrest even for these low-level offenses. So it's not in all circumstances, and it's, again, the citizens expressing the will of, hey, we have, violent crime we would like the cops to go over here and focus on. And I think that when you look at the statute, and it does still allow citation and arrest in the circumstances, all of that is in harmony. And I think, again, it's in harmony with other state laws, in harmony with the way federal law looks today. And so it's not preventing full enforcement. It maybe makes enforcement look a little bit different, but it makes enforcement look like what the will of the people want.
So is full in the eye of the beholder? And if so, is that in the eye of the state or is that in the eye of the city?
Full enforcement is, well, again, all the offenses are still in the books. So the offenses aren't wiped clean. The ordinance, the enforcement ordinance doesn't say these offenses just go away. It just means that how we allocate our resources looks a little bit different. So I don't think that full enforcement should be read, and this maybe goes to what is full enforcement, but full enforcement should not be read to create affirmative obligations here, because again, that wades into the purview of discretion. And so I have a little more time, but I want to talk about
So let me ask just the big question here. State law is supreme over local law, right?
yes.
Even though we don't have a supremacy clause. And the only way the railroad runs is if everybody, like it or not, the U.S. Supreme Court does some things that all of us, left, right, middle, in between, don't like. But the railroad only runs if everybody, including all judges who've sworn to uphold the laws, say, well, that's what we'll do. And this doesn't look like that. This looks like a city or two that didn't like the drug laws on minor possession of marijuana, which they're entitled to that possession, and they may be right or wrong. But how do we run this railroad if local governments and local judges won't follow state law?
Well, again, I don't think that it's a failure to follow or comply with state law, because these offenses are still in the books. These offenses are still being enforced. They're maybe being enforced a little bit differently, but different is not no enforcement. And I would also say that
the enforcement is, we'll take away your marijuana or hemp, whatever it is. And as long as you don't do something where it's not part of a larger drug offense, you're not going to be prosecuted. That can't be full enforcement. It is enforcement of a type, I'll grant you that, but it's not full enforcement.
Well, I think when you're talking about full enforcement of the drug laws of the state, I do think that there is full enforcement that captures the whole statutory and regulatory scheme. And is overall, are we enforcing all of these drug laws? And again, it has to comply with state law, it has to comply with federal law, and so it's all of those that have to be read in harmony. And when you read all those in harmony, I think that this is full enforcement. And so since I am about out of time, I'll just say that, this is a case about municipal governance and the right of not just the cities, but the citizens to govern themselves. Because I want to impress upon you that these are citizen initiatives. And so here what we have is a clear intent to suppress the will of the voters and how they allocate their resources and keep their communities safe. And that's not what the statute tells us to do, and that's not what we should be doing, but that is what the state is asking you to do.
Thank you, Mrs. Smith.
Thank you.
Mr. Scanlon, I believe you have 8 minutes.
May it please the court. What the city of Austin is asking the court to do is interpret the statute into a vagueness problem, and that's very clearly not how to follow the doctrine of constitutional avoidance. So the limiting construction argument on vagueness should be rejected, even if you even reach that question, because as I argued earlier, the city doesn't have due process rights that it can assert here. I think the standard that was proposed, that it's vague to the point of being no rule, while that is the civil standard, I think that you get there only if you find that there's a statute here that infringes on individual rights. The vagueness doctrine is meant to protect those rights, and it's not meant to protect against unfair punishment. And that's really ties back into the preemption question. the standard here is whether the legislature intended with unmistakable clarity to preempt with its intent, not necessarily with the language. And
Can you help me how we're going to order repeal of an ordinance? Because you're asking us to not just declare it unenforceable or improper or preempted, but to order repeal?
yes, Mr. Chief Justice, that remedy is available.
As some kind of affirmative injunction or a mandamus? You people get together and meet and repeal this and wipe it off the books?
That would be how it would happen, Mr. Chief Justice. I think the justification for that, as you mentioned, is in the Constitution, the statute itself, the specific prohibition we're looking at here, that they may not adopt a policy. I think that gives the court authority to order a repeal.
Is there a case where that's happened, where,
There was one with the city of Houston, and it wasn't in our brief, but it was.
You can
it was
just send it in a letter and you all can respond to it if necessary.
Well, it was
But
in their.
I mean, we're a brand-new court. That's fine. We hate to do brand-new laws that have never been done before, so.
Yes, Mr. Chief Justice. I can say about that case, the remedy of repeal was in the charter itself. So I don't know if that's directly on point, but with this being the statutory mandate, may be more appropriate at the permanent injunction phase as opposed to the temporary injunction phase. But repeal is an available remedy for state statute.
could we also talk about the temporary injunction relief that's been sought? As I understand, it was phrased as full enforcement. And you're arguing that the court could have ordered something other than what was specifically requested?
Well, Justice Ferris, the injunction seeking full enforcement is really just kind of alluding to the statutory language
But the
here.
statute itself doesn't compel full enforcement, it just prohibits a bar to full enforcement. And as I understand, those are conceptually different things.
Yes, Justice Ferris. So it would be a little, I guess, let's say inartful to say fully enforce the laws, and we've taken the position, as you said, that it's really about preventing the policy from going into force.
Well, I guess I'm just wondering, if this goes back to the trial court, would it just be cleaner to have a new request for a temporary injunction that doesn't say full enforcement?
The court can certainly remand with instructions to enter an injunction in line with the opinion or whatever the court rules. The Vahl case, the reasonable construction rule that they're talking about, if you have two statutes, doesn't really come into play here because there's an express limitation, and the cases have said if they're, you can maybe read them in harmony, there may not be a preemption problem, but here you have an express limitation on the authority to adopt this ordinance. So
I'm troubled by Ms. Smith's argument. So got a city council say, we're not going to pass that statute, that ordinance, because the state says we can't. So the people get a petition, an initiative, referendum, and they've got to canvass it. And so what are they can either refuse, it reminds me of a vice president being asked to refuse to count the electoral college votes, that puts you in a difficult position. So here there are people that are voting in and out of office saying, we've passed this, you need to canvass it, and the city council was supposed to say, no, we refuse.
Well, Chief Justice Pritzker, you don't actually have to reach that question here. We would submit that the acts of canvassing, declaring the results of, and adopting the ordinances are all distinct. And what the statute says is you can't adopt it.
So you've canvassed the votes, you said it passes, then what does the city council do to adopt?
They're basically saying that they're passing a resolution adopting the ordinance as a result
When
of
they
the votes.
canvass the votes, when they certify the results of the election.
Right, and I think the language that Ms. Smith brought up, that it's when they canvass the votes is when they adopt the ordinance. So you can canvass the votes, but you can refuse to adopt the ordinance if it violates the Constitution so clearly as it did here. Addressing the immunity argument, That's essentially foreclosed by Hollins. And just on the point about the arrest, if you're not arresting, you're certainly not fully enforcing. You may reach a measure of full enforcement if there's a citation, but I think that a prohibition on arrests for a criminal statute violates the prohibition in 370.003. The railroad certainly can't run on time if the measure of making an arrest is not available in the first instance.
Let me go back on the claim, on the ultravirus claim. If the adoption of the ordinance is the ultravirus act, then what's the prospective relief we would be enjoining for the ultravirus act?
As to the city council members,
Yes.
it would be further implementing the ordinance, passing any measures to further implement it, or taking any disciplinary action as against the city manager if the city manager refuses to implement the ordinance. Those are the kinds of prospective relief we're looking for. It's also, I think that the city council members need to be included in the ultravirus declaration because the statute says that they may not adopt the policy. So to carry that out, they would have their proper defendants for the deck action as well. Regarding the testing of THC, there's record evidence that that's not the only way to approve or to proof problems basically don't cause the inability of the officers to make an arrest in the first instance. And that kind of goes back to what Chief Stanridge testified at the beginning, that he was opposed to the ordinance. And I see I'm out of time. If there are no further questions, we ask that you reverse.
Thank you, counsel.
Thank you.
Thank you for bringing us two such interesting cases. It makes me wish for the days of presiding over car wrecks and slip and falls at the grocery store. I suppose that's not what this court was created for. So we'll take a brief adjournment, be back in about 5 or 7 minutes, and take the next interesting case. Thank you.
All rise.
Be seated, please.
I guess I can move this back a little bit. Our next case on the docket is In Re Office of the Attorney General of the State of Texas. Mr. Stone, you may proceed.
Thank you, Your Honor. May it please the Court, this case represents a direct attack on the Attorney General's constitutional, statutory, and common law authority to conduct investigations into corporate entities in the state of Texas to determine if they are exercising powers not authorized by law. The question before the Court today is, did the trial court abuse its discretion in denying the Attorney General's Rule 202 petition, where the Attorney General has the authority to take pre-suit depositions as a matter of law, and where the competent evidence showed that the benefit of taking a pre-suit deposition greatly outweighed the procedural burden on CCRGV? This Court should find that the trial court did abuse its discretion. First, the Attorney General has the authority to conduct pre-suit depositions of corporations as a matter of law. The Texas Constitution states that the Attorney General shall especially inquire into the charter rights of all private corporations and from time to time initiate court proceedings to prevent them from exercising any power that is not authorized by law. That is codified in the Texas Business Organizations Code, which authorizes the Attorney General's office to conduct investigations and to examine the records of corporate entities. If it determines that they are engaged in conduct or exercising any power that is not authorized by law, the Texas Government Code and the Civil Practice and Remedies Code authorizes the Attorney General to initiate quo warranto proceedings to revoke the charter of those corporations. In Humble Oil, the court held that the Attorney General has an unlimited and unrestricted right of visitation as to the visitation powers that it has. The same is true of its investigative powers. This court should find that investigations necessarily include depositions. They can include lots of other things too, but they also include depositions.
I'm sorry.
If that's true, I know the Attorney General seeks documents from corporations all the time under the investigation statutes and doesn't have to file a lawsuit to do it, usually. If that's true that as a matter of law, those same statutes give you the power to take a deposition, then why do you need Rule 202 as a proceeding?
We have it's belts and suspenders as the idiom goes, where we've got a variety of tools. So we can request deposition upon written question, we can take examinations under oath, we can send subpoenas, and we can deploy Rule 202. In this case, we chose to use Rule 202 as the procedural mechanism to take the pre-suit deposition. But there are a variety of other tools that we could have used, did indeed attempt to use in this case to obtain a pre-suit deposition. If you look at Exhibit 1 and the mandamus record, we opened with a request for them to appear for an examination under oath, which is similar to a pre-suit deposition.
But what, go ahead.
So take those one at a time. The alleged common law right or arising implication from the Business Organizations Code. How long has investigate been in the statute?
The word investigate has been in the statute since its inception in 1907, I believe.
Right. So according to Professor Dorsanio's article on the Texas Rules of Civil Procedure, oral depositions as we know them, deposition meant something different in 1907 than it did now, because all you could do was discovery related to the other side's pleadings. And he says in this lead law review article, which I'll give you the citation for, that in the old statutes, when they said deposition, what they meant was a deposition on written questions, which is basically you sent somebody written questions, they conferred with their lawyer, they showed up in front of a stenographer, and they read out their answers. It wasn't until the scope of discovery was expanded in the 1940s, the options of the Rules of Civil Procedure, and wasn't expanded in practice till the 60s, when it was relevant not just what was pled, but what might lead to admissible evidence. And so he argues that oral depositions did not mean what you and I think of as an oral deposition until long after investigate was demanded. Now, assuming he's correct, and I don't know, I'll give you some time to look into that and respond if he wasn't. But I recall several Supreme Court cases that appear to, what, in the 1800s, that appear to support that, then we have to apply what depositions meant and what investigation meant. Investigation may have included depositions back in 1907, but not like we're talking about today.
Your Honor,
It's a lot, I know.
this wasn't a topic that we briefed, but my initial reaction to that is I would like to point out to the court that this particular statute in the Business Organizations Code has been recodified multiple times, 3 times, I believe. Most recently, I believe, in the 1960s. So the legislature, when it adopted the most recent version of this law, would have been aware that investigations could have included oral depositions, and that depositions at that time could include not only depositions upon written question, but also oral depositions.
It's, by the way, it's Baylor Law Review, Volume 65.
Thank you, Your Honor.
Just, yeah, take a look at that after argument. I'd hate to spring that on you, but it's, I didn't know that. None of us were around in 1907. I doubt if you would have knowledge of it either, but let me know on that because I am troubled by that. And why has the question never arisen till now about this common law power to take oral deposition?
Well, it just hasn't been challenged, Your Honor, before. The Attorney General's office has deployed a variety of investigative tools in the past. This is just the first time, to my knowledge, that the Attorney General's office has attempted to use Rule 202 to obtain a deposition in this kind of context, and where it's been challenged and has come up before a court of appeals.
Once you invoke Rule 202, though, don't you come under the case law that defines the trial court's discretion and the benefit, weighing benefit and burden, which seems very discretionary? But you say it's as a matter of law. Are you saying the trial court has no discretion if the AG says we want a corporation's deposition?
Because we decided to use Rule 202 as the procedural mechanism in this case, the court does have discretion. But what our argument is that the Attorney General's office, the constitutional, statutory, and common law powers of the Attorney General to conduct investigations of corporations acts as an anvil on that scale as it's conducting the balancing test.
Can you walk us through that balance and how it plays out here?
Yes, Your Honor. So in this case, the balance that is conducted under Rule 202, where you first, to tee that up, the Attorney General's office has to show that what is the subject that it seeks to investigate with the Rule 202 petition and its interest therein. We've satisfied that in our Rule 202 petition, as you can see from the record, by identifying what we're specifically looking at with the corporation and our authority to look into CCRGV in this case, and its basis, which we've talked about already, the Constitution, the Business Organizations Code, and the common law. The balance itself is, in Rule 202, is looking at whether the likely benefit to the Attorney General's office is greater than the procedural burden on CCRGV. In this case, and there is a scenario where, despite having significant powers to conduct investigations of entities like CCRGV, where the burden still might be appropriate, where the Attorney General's office could lose. For example, a time, place, manner. If we noticed, we sought in our petition, our Rule 202 petition, to depose CCRGV in Alaska at midnight tomorrow, and we gave them 350 topics that were broad, that might weigh against granting that Rule 202 petition, despite having our powers to investigate corporations. So, but that's not the case here. We have 4 discrete topics, and in the Rule 202 petition, we said that we were willing to work with CCRGV to find an appropriate time, place, and manner to conduct the deposition. Now,
What is the necessity, though, of doing this all pre-suit?
Yes, Your Honor. So the only way to do it post-suit is if we brought a quo warranto proceeding seeking to revoke their charter. The purpose of the Rule 202 deposition is to conduct investigations into potential claims. So Rule 202 gives us the ability to look into and determine whether or not there are grounds to bring a quo warranto lawsuit in the future. Here we have exhibits 1 through 11 that show over a 3-month period we went back and forth with CCRGV, asking for documents, asking them to provide, to come and sit for an examination under oath. We sent them questions and they returned a sworn statement, which we found to be evasive. We made multiple efforts over a 3-month period to try to obtain information. And what they did is they did these little breadcrumbs where they trickled it along and they gave us little pieces of information and dragged it out. And ultimately, the Attorney General's office concluded that the most efficient way to get the information that we need for our investigation is to just come sit for a pre-suit deposition, not trickle things out over the course of months or a year. We just want them to come and sit and answer questions. That's particularly useful in this context because CCRGV, as we learned from Exhibits 1 through 11 in the mandamus record, doesn't have written policies for much of the information that the Attorney General seeks about how they intake certain migrants into their facilities, how they interact with law enforcement. There's a lot of information that we want to obtain from CCRGV that we can only obtain from a pre-suit deposition.
And what violations of state law do you think they may be committing?
They could potentially, depending on what we learn, potentially be violating the Penal Code Section 20.05A1. That makes it unlawful to use a means of conveyance to transport an individual.
So you think they're using motor vehicles or aircraft or watercraft to move people? Seems like you could get a video of that.
That would be one of the investigative tools that we are authorized to use. Again, pre-suit depositions are another tool. We also, and that is that's one potential provision that they could be violating. We do have reason to believe that they're transporting migrants using vehicles, by the way, to Anzalduas Park. But we'll learn more information about that once we take the pre-suit deposition.
But isn't the problem here, though, that what I'm hearing is the Attorney General says they're being evasive, but then it goes to the trial court who has a discretion to weigh the evidence, and he or she, the district judge, may decide they're not being evasive, they're actually answering your questions. So how do we decide, you know what, AG, you're correct, they're evasive, therefore, as a matter of law, you had to get the 202 deposition, when the Supreme Court has told us that a trial court has discretion to weigh the evidence?
The evidence that the trial court should be weighing is whether or not the likely benefit exceeds the procedural burden. And I want to emphasize procedural burden. That's time, manner, place. That's what the balance is here. Again, the trial court could look at and determine whether or not the CCRG is being evasive, but that's sort of beside the point. The bigger issue is what is the likely benefit of a pre-suit deposition? And here we've shown through Exhibits 1 through 11 that there is a likely benefit to the Attorney General's office because most of their policies and procedures are not written. So the only way that we're going to get them is if we have them come in and sit down and we can take a pre-suit deposition. If we can't do that, then organizations could simply avoid regulation by the Attorney General's office writ large if they just never write anything down. We'd have no ability to conduct examinations of them because we can never bring them in to actually sit for a pre-suit deposition.
So what are the limits of this? The Supreme Court said in 2008, 202 depositions have never been intended for routine use. They're practical as well as due process problems with demanding discovery from someone before telling them what the issues are. What possible limits are? It just sound like you said, well, you certainly argue violation of state law is a benefit to the state, and so anytime the Attorney General thinks somebody's violating the state law, you have a right to take a deposition, pre-suit deposition.
Two things in response. One, the fact that this has not come up before the court before shows that this is not a tool that we regularly use during the course of investigations. I think
Not yet.
But didn't you also say there's an anvil on the scale
Our contention,
in your favor?
Our contention is that there is an anvil on this scale. So if we do use this tool and continue to use this tool in the future, we think that it operates, again, as an anvil on the scale. But there are limits, and I talked about them, the time, place, manner. That's the limitation, that procedural burden on the respondent in the case. That is the limit.
But the fact is, you get to take it in any case you want.
Yes. The only limitation being the procedural burden. That is the limitation, not setting it, again, in the middle of the night or some...
Right.
Crazy criteria.
And there are a bunch of these, but there are a bunch of these almost exact cases pending in the appellate courts right now, right?
There are other cases that involve a request to examine records and other tools, investigative tools that have been used by the Attorney General's office when looking at private corporations in the state of Texas. But there are no other cases that I'm aware of involving Rule 202 and that specific procedural mechanism that are before the courts of appeals in any federal or state court. For all the foregoing reasons, we'd ask that this court reverse the trial court's ruling and direct it to enter judgment in favor of the Attorney General's office on its Rule 202 petition. Thank you.
Thank you, Mr. Stone. Mr. Powell.
Good morning, Mr. Chief Justice, and may it please the court. Rule 202 depositions are disfavored. As you mentioned, the Supreme Court of Texas has explained they are not for routine use. They raise due process concerns, and if abused, they could become a license for forced interrogations. To ensure that Rule 202 applies only in appropriate cases, the text of the rule itself requires that a party seeking a pre-suit deposition to investigate a potential claim, as the Attorney General says he is doing here, must present evidence proving that the likely benefit outweighs the burden or expense. The Attorney General did not meet that demanding standard here. He presented no evidence whatsoever to the district court suggesting that there's any basis for his investigation or that there would be any benefit to a deposition. At the very least,
Go ahead. The same Dorsanio article I mentioned seems to treat the oral deposition on answers to written interrogatories from 100 or more years ago, more than a century ago. That's when somebody was about to die or going to move out of state or something like that, and it was limited to circumstances where somebody wasn't going to be around for trial. And is there any limit like that? The rule doesn't say that anymore, that it's limited to people that are not going to be available at trial. And we wiped that out from oral depositions generally, even if you can do pre-suit depositions. I mean, you can do post-filing depositions anytime you want. But is there haven't we done the same thing with 202 depositions? That's not limited to people that are about to die or anything like that.
So there are two different prongs in the text of Rule 202. And Mr. Chief Justice, the 202.1 lists the two different reasons that you can take a pre-suit deposition under Rule 202, and I think A is the one that you might be referring to, which is to perpetuate or obtain a person's own testimony or that of any other person for use in an anticipated suit. And then there's a different showing that you have to make to get that kind of a pre-suit deposition. The Attorney General has not sought that type of a pre-suit deposition. The kind they are looking for here is under 202.1b, which is for investigating a potential claim. And that's where you have to do the benefit versus burden analysis. And the Attorney General said,
considering many factors and a balance and all the things that are wrong with balancing tests.
It is a balancing test that is in the rule, and so it is one that the district court has to conduct. But I think surely mandamus relief is not appropriate here, where there was almost no evidence in the record, and the district court made that fact-bound determination to balance the burden and the benefit and came out where he did. So I think the only thing really that the Attorney General can say is, I didn't have to present any evidence because I automatically win because I'm the Attorney General. No court has ever held that the Attorney General satisfies Rule 202 as a matter of law. There's no support for that in precedent, no support for it in the text of Rule 202, and no support for it in the text of the Business Organizations Code.
But apropos of my argument about running a railroad in the previous argument, this issue is fraught with political differences. And it may be that the judges in a particular locality are for or against people seeking asylum in this country. And how do we ensure that that doesn't end up putting an anvil on this side of the scale or that side of the scale? And so that we have the same rule in the Valley that we have in El Paso and everywhere in between and Texarkana.
Sure, Your Honor. So I, again, want to separate the two arguments that they're making, because the anvil argument that's on their side is a purely legal argument, and I think you can consider that just as a matter of law. As for your review of the balancing of benefits and burdens, which is what I take you to be asking about, what if courts are too skeptical of the benefits because they're too supportive of immigrants or something like that? I think, or vice versa.
Right.
I think there you have the mandamus standard, and if there is a clear abuse of discretion based on the evidentiary record, then of course you can issue mandamus and require the court to reach a different decision. But here, again, this was an evidentiary hearing, and they came to the evidentiary hearing without any evidence other than documents that we ourselves produced that show that we comply with the law, that we only take non-citizens at our humanitarian respite center who have been processed by the federal government, who have been given paperwork, and who are in the country lawfully. There was also a sworn statement by Sister Norma Pimentel, the executive director of CCRGV, in which she swore under oath that they only take immigrants who have been processed by Customs and Border Patrol and who have proper documentation. I don't understand how they could think that a deposition of Sister Norma is going to produce anything different than what she already swore under oath.
Maybe they
to
have
the
some
case.
Perry Masons that cause the cross-examine. Okay, you're right, I did the murder. Maybe they're such good cross-examination. What's the risk if Sister Norma is unlikely to break down under cross-examination?
Well, I think there are three relevant burdens, Your Honor, that I would emphasize here that were in the benefits versus burden calculus. The first burden I would mention is the scope, which is, I think, the one that courts most often look to and that my friend highlighted. It is true that they mentioned 4 topics, but those 4 topics are really quite broad. And if you look at other cases where the burden was found to be low, like the Dallas case that they cite, there the burden was really only, or the limited topics were really only about one element, say, of a claim. Whereas here, the 4 topics cover basically every possible aspect of the operation of the humanitarian respite center. Just one of those 4 topics was CCRGV services provided to aliens as part of their humanitarian crisis response program, including, but not limited to, services provided through its humanitarian respite center. So that's really quite broad. It's a lot of topics. So that would be the first burden, I think, that's relevant here.
Do
The
they
second
have to
burden-
show a violation of the law to get a 202 deposition?
No, Your Honor. For purposes of a 202 deposition, we agree with the Attorney General that they don't have to show all the elements of a claim, which I'm not sure if that actually answers your question. So maybe let me take it in 2 parts. They don't have to show all the elements of a claim for purposes of getting a 202 deposition. So whatever civil claim that they're trying to pursue, I think they have to show at least enough evidentiary basis for that type of claim that you could understand, oh, if we order a deposition, they might be able to find something here. And I would point you to a couple of points of reference for that. The first would be cases, including ones that my friend cited in his brief, where courts have found a sufficient benefit. One of those is the In re Tatum case. In that case, a woman was sexually assaulted by a police officer who was responding to an ambulance call. She had a lot of facts that were relevant to the claim that she was likely to bring, to the potential claim. She understood the wrong that had been committed and basically who had done it. And what she needed to do was just to understand a little more about the police department's policies so that she could understand whether she might have a 1983 claim in federal court. I would also point to the drilling contractors case. That was one from the First Court of Appeals. There, a defamatory safety alert was posted online about this company's operations. They knew that the defamatory alert was out there and sort of what their claim was going to be, a claim for defamation. What they didn't know was who had reported the safety alert to the reporting agency, and so they just needed that small sliver of their claim to be filled in. That's the kind of thing that is a benefit for Rule 202. It is not just a pure fishing expedition where we don't know, we're hypothesizing that there might be a problem. I would also point, as a point of comparison, Your Honor, to both the Annunciation House case that is pending before the Supreme Court of Texas and the Fiel case in which this court heard oral argument a few weeks ago. I think what we've seen is perhaps some overreach across the board to go straight to quo warranto in those cases. But I think for purposes of 202, the kind of evidence that the Attorney General put forward in those cases, where they had, in the Annunciation House case, it was statements from the director of Annunciation House talking about serving non-citizens who were undocumented. In the Fiel case, I think there were like flyers and social media posts that they claimed violated the tax laws. And so there were at least some specific evidence to support the claim, but there's nothing like that here.
So that of course is the alternative. They could have just filed a quo warranto action to revoke your charter and then do the discovery afterwards. How is this worse than that?
This is not worse than that, but that would be very, very bad, and this is very bad. This is just a little less bad.
But it seems like they're
Let
saying.
me write
if
that
they-
down.
It seems like they're saying if, this is the alternative, that things will get very, very bad if we don't have this particular tool.
So I don't think that's right, Justice Ferris. I think, as he said, they have many tools in their toolbox short of Rule 202. Here, they chose to bring a 202 petition,
Sure.
so I think they have to comply with Rule 202. But they could have, we agree that under the Business Organizations Code, they can get records. And I take him to be making a sort of slippery slope argument that people aren't going to keep records. We have a lot of records. And actually, we created some records to try to take our oral policies, put them in writing so that we could explain what those policies were to try to be very forthcoming with this investigation. So we're not trying to be evasive whatsoever. And I think they also, they have investigators. They can pound the pavement. They can talk to people, get some kind of leads, do the sort of police work that any kind of organization would do. And then once they have a factual predicate for their investigation, then by all means, come get a 202 deposition. But they have to have at least a little bit of a factual predicate to start, and that's what they didn't have here. If I could return quickly to the burdens, because I think I got through 1 out of 3. The other two, and I think maybe this goes a little bit to your point as well, Justice Field, is that although it is with an eye toward a civil quo warranto proceeding, the violations that they're alleging here are criminal violations. And those are pretty serious allegations against a nonprofit organization. And I think it makes the deposition quite a bit more burdensome that we're going to have to prepare for potentially Fifth Amendment issues that might come up. Of course, we could address that on a question-by-question basis. I'm not arguing that. But just that is going to make it a more burdensome deposition. And certainly Rule 202 is a civil rule. It is not supposed to be, generally speaking, for investigating crimes.
Well, you anticipate a little bit of a question I already had for Mr. Stone on rebuttal, so I'll give him a head start, which is, if we have Sister the nun, I assume, under oath saying, we didn't do this, and then you depose her, and you're trying to establish, yes, you did, and it's criminal, why could the trial judge look at that and say, so basically we're going to have a deposition of invoking the Fifth Amendment over and over and over again, and what is the benefit of doing that?
And I would mention, Your Honor, that actually that did come up in the hearing transcript if you take a look at it, and the judge did say that he had a concern about the potential Fifth Amendment ramifications here of this deposition, so I think that's totally a fair concern. The third burden that I would mention on the burden side of the scale is that this is a religious organization. Just as they don't have to plead all of the elements at this point yet, we don't have to raise Texas RFRA as an affirmative defense at this stage because it's just a pre-suit deposition. But I still think that the kind of religious burdens that could be put on Sister Norma or whoever gives the deposition by this deposition are cognizable under Texas law, or things that you should take into account in doing the benefit and burden balancing under Rule 202. And in particular, I think some of these topics that they've outlined that are about how they operate the Humanitarian Respite Center could go to things like their association with other religious organizations, the way that they interact with the diocese. They've mentioned Catholic Charities USA in some of their paperwork, which is actually a separate organization. And so it could pry into some sensitive, to some extent at least, religious associations. The last thing I would also say about how the test applies is that not only do you have to have the benefit and burden balancing, but you do have to have a potential claim. And I think this goes to your point as well from earlier, Justice Field. There is, I think, some lack of clarity in the law at the moment what their potential claim under quo warranto might be. The Texas Supreme Court may weigh in on that in the Annunciation House case. This court may weigh in on that in the Fiel case. And I don't want to get out too far ahead of those. But I think there is at least a plausible argument that in order to bring a quo warranto action based on a criminal violation, there has to first be charges and a conviction. And of course, there's been nothing like that here. And insofar as that is the correct reading of the law, which I think Annunciation House has argued in their papers, then there would be no potential claim here, and that would be another reason that the Rule 202 proceeding should fail. I also wanted to mention, I think my friend suggested there might not be any other Rule 202s. This was one of a kind, but there is a Team Brownsville Rule 202 petition as well, and I believe that is now pending before this court as well. I don't have the case number right in front of me, I apologize, but that is at least a second Rule 202 case that is pending before this court. The other thing I wanted to mention is, sorry, I lost my place in my notes. basically, with respect to the visitorial statute, I'd like to make two other points about it because we haven't talked about it too much, the as a matter of law argument. First, I think it just doesn't really matter to Justice Field's point from earlier because he has come to court here under Rule 202. And so to use Rule 202, he has to meet the same standard under Rule 202 as anybody else, no matter what authorities he may or may not have under the visitorial statute. The other thing I would say is that there are serious constitutional questions about the visitorial statute. A federal court has now declared that statute facially unconstitutional. That's been appealed to the Fifth Circuit. But of course, insofar as that statute is unconstitutional, to your point, Chief Justice Brister, about the how to run a railroad and who's in charge, if that is declared unconstitutional, then of course they cannot rely on it here. I would also say, just as a matter of text, I don't think that the text of the visitorial statute, even separately, provides power to take depositions for the sort of textual reasons that we explained in our brief. And with that, I think I've made the points I'd like to make. If there are further questions, I'm happy to address them, but otherwise I'll sit down.
You're very efficient, Mr. Powell. Thank you.
Appreciate it.
Mr. Stone?
Before you get going, I know you've got a lot to cover. Could you address the point about the relatively thin evidentiary record here?
Yes, Your Honor. We don't agree that it's relatively thin. We are only required to, so set aside the Anvil argument, set aside all of that. Like, let's just do the balancing with the evidence that was presented. They presented no evidence during the evidentiary proceedings, none. There's no exhibits from CCRGV. They presented no evidence as to the procedural burden on them. So at most, it is de minimis on the scale, the balancing scale for them. On our side, we presented 14 exhibits, of which 13 were admitted. The exhibits 1 through 11 show the attempts over a 3-month period to try to obtain information and how it was unsuccessful from CCRGV. It was unsuccessful for several reasons. One, because we were seeking written records from them and they don't have written records for a lot of the information that we seek. Then we sent them questions and they agreed to provide us with a sworn statement in response. That sworn statement in response we determined to be evasive. I'll give you a concrete example from that. We asked them to identify the CCRGV folks who talked to CBP and ICE officials. The response says, and you can see it in the record, I believe this is Exhibit 11, the response is CCRGV representatives contact and communicate CBP and ICE officials. Well, we asked them to identify the actual individuals, and the response was CCRGV folks do talk to CBP and ICE. It's one example of the evasive responses we got from them. So we determined that the likely benefit here, and we believe that the trial court got it wrong, the likely benefit of a pre-suit deposition exceeds the procedural burden, because in this case, we can keep doing this little trickle where we're trying to figure out what exactly the right question is where you don't have any documents, right? And each answer we get to a question's 1 or 2 sentences long, or we can just bring you in and sit down and just resolve this in one setting with a pre-suit deposition. Which leads me to the next topic. My friend on the other side mentioned that the topics are so broad that it would be very burdensome and difficult for them to respond to. Well, I'd like to quickly go through at least a couple of them. The first one is the 4 topics. The first one is CCRGV services provided to aliens as part of their humanitarian crisis response program. Unless they provide unlimited services, that should be a narrow topic that lists just the services that they provide. That's not an unlimited topic. And more importantly, the 4th topic is CCRGV's practices for facilitating alien crossings over the Texas-Mexico border. So if that's a very broad topic and there's a lot to talk about, that's certainly a topic that we'd like to get into with them. That's a red flag for us when they indicate that that's a very broad topic that they would have a lot to say about, and that the scope is very broad for them. If the answer is anything other than none, we have a lot of follow-up questions that we want to talk about with them on that topic, which goes to the 5th Amendment question that was brought up. The 5th Amendment was brought up during the trial court proceedings, and our friends on the other side said that they had not raised it to that point. They didn't anticipate raising it, but if it did come up, they would raise it on a question-by-question basis. The 5th Amendment isn't a writ large to just never take a pre-suit deposition. If it were to come up, they could raise it on a case-by-case basis, and then it would be for court to determine whether or not to permit that privilege to be invoked.
Let me ask you, how is what you're proposing to do, either under the common law investigation or the business organizations code, Is it the same as or different from a civil investigative demand?
It's different. It's similar, but it's different. It's one of the many tools. So what we're attempting to do here, so a civil investigative demand, we could ask for records. We can ask them to produce different things. We often use a civil investigative demand or a CID in Deceptive Trade Practices Act
And
investigations.
they generally authorize you to examine under oath any person.
Correct.
We don't have that in this case.
In this case, the way that the Business Organizations Code is written, it's much broader. It just says investigate. And we interpret that broadly. We have the full plethora of investigative tools that the Attorney General's office deploys. They're all available because the statute doesn't say you can investigate and only investigate using this particular tool, or only investigate using that particular tool.
And again, about doing brand new things, has this ever been, any case, ever addressed this issue before?
In Humble Oil, the court did look at this statute, and it said that the Attorney General's authority was unlimited and unrestricted as it related to requesting records under the Business Organization Code.
Set aside records. I don't think they're contesting records, and records is pretty clear, but whether investigates enough to get an oral deposition, any case, this will be the first case that ever says one way or the other on that.
Your Honor, I see that I'm out of time.
Yes, please answer.
Yes, this would be the first of its kind, but we believe, even again, setting aside the AMVL and entitlement as a matter of right, that based on the Rule 202, the competent evidence introduced during the Rule 202 petition proceedings, the Attorney General's office demonstrated that the likely benefit to the Attorney General's office exceeds the procedural burden on CCRGV. Therefore, the trial court's ruling was an abuse of its discretion, and we ask you to reverse and remand with instructions to enter judgment in favor of the Attorney General's office on its Rule 202 petition. Thank you.
Thank you, gentlemen. Anything further? We'll take again a brief adjournment, a brief break until we return for the final case. Thank you.
All rise.
Thank you. Please be seated. Last case on this morning's docket is State of Texas versus Harris County. Mr. Mendelson.
Mr. Chief Justice, and may it please the court. The Texas Supreme Court has already held that the original Uplift Harris program is very likely unconstitutional because it lacked constitutionally sufficient controls as the gift clauses require. Their new argument and their new program is no better for largely the same reasons that our Supreme Court already articulated. Perhaps realizing that problem, the county has attempted to insulate its new program from judicial review by contending that the Attorney General has no common law rights, an argument it failed to make in the Uplift Harris case just a few months prior. I'd like to begin there and then address why the county's new program still violates the gift clauses. Harris County's argument proceeds from the wrong premise. The Constitution and all statutes of this state are written against the background of the common law. Section 5.001A of the Civil Practice and Remedies Code adopts the common law by statute. And in modern Texas Supreme Court cases like Taylor v. Tolbert, the Texas Supreme Court has explained that we need a clear statement rule from the legislature or the Constitution to repeal the common law. And we know that that hasn't happened here from several cases, the most important of which is the Hollins case from 2020. That was the case in which the Texas Supreme Court, in a case procedurally identical to this one, held that the state had the intrinsic right to enforce its own laws. And when I say procedurally identical, what I mean was that the state, acting through the Attorney General, brought a common law ultra-virus suit against Harris County officials for violations of certain provisions of the Election Code, procedurally the same as this case. And in that case, the court held, we reiterated that as a sovereign entity, the state has an intrinsic right to enforce its own laws, and where those laws are being defied or misapplied by a local official, the ultra-virus suit is a tool to reassert the control of the state. Hollins also drew on some very important prior Texas Supreme Court cases like Yet v. Cook in discussing these common law powers. Yet v. Cook explained that under the ancient and modern rules of the common law, this is page 221 of Yet v. Cook, the state has a sufficient interest to and can maintain an action, in that case, against municipal officers to call an election. It then said, since the state can bring a proceeding in equity, it was talking about a mandamus suit in that case, similar to the one before the court there, it's elementary that the Attorney General has the power to institute such an action. That is essentially the basis of this suit. And there's also another important case in the same vein that shows that the common law hasn't been repealed. And that's a case from 1893 called Queens Insurance Company versus the state.
Is there anything in the, again, I'm nervous about being the brand new court doing something brand new. I understand 19th century cases are not brand new, but it's been a long time. Anything about common law right to just file suits that in more recent years?
I think Hollins is the perfect example of that. Hollins was a case from 2020. And of course, since Hollins, certainly the Texas Attorney General's office has used the ultra-virus cause of action many times against various local government entities. So this is a relatively common procedure, certainly since Hollins.
And so, similar to our earlier case today, is the basis for jurisdiction against the county, is the Uniform Declaratory Judgments Act, basis against the county officials is ultra-virus?
So the basis against the county officials is the ultra-virus cause of action. The basis against the county entities is City of Elsa and City of Beaumont v. Bullion, which is the implied right of action in equity, of course, not for damages, for constitutional violations. So that one is the proceeding against the entity, but of course, what I was also referencing was the ultra-virus cause of action.
Got it.
So that is the basis for how the Attorney General can bring this suit in the first place. And I suspect that my friend on the other side might bring up some cases like Harney and Garcia, but those are cases that are about statutory causes of action. They're not about common law rights of action. And that's also a very important distinction because I suspect my friend on the other side is going to bring up a case called Paxton versus Longoria. And I want to be extremely clear, the Attorney General's office has not contradicted the litigation position that it took in Paxton
We
versus
got that,
Longoria.
got that in your brief.
Right, that was a statutorily created cause of action for civil penalties, and I just want to be clear that on pages 42 and 43 of that brief, argument heading 3C, we said we could use the ultra-virus cause of action, and we specifically discussed the
And
Hollins
so
case.
the appeal here is on the temporary injunction. We've had a final judgment entered. Straighten me out on how, what issues the final judgment merges into issues that were briefed on the temporary injunction.
Sure, so several issues. One, of course, is they brought up the issue I was just discussing. One, of course, is the gift clauses, the actual merits of the case. And I do want to be sure to turn to that now.
Well,
And
before you do, just to follow up on the chief's question, and I just may be missing something, but if a court decides it has no jurisdiction over an action, how does it then amend its judgment to say, oh, and in addition, I'm going to grant the motion to show authority, even though I don't have jurisdiction to do that?
I think that's a fair point to make. My friend on the other side relied, I believe, on the plenary power of the court within 30 days. We're not here to dispute that, only to note that the judgment, of course, has been superseded under a 27-3 notice. So to the extent my friend on the other side argues that the pleadings have been struck, well, that's not actually true. That entire judgment was superseded by the state supersedious. I'm not sure if that was the court's question.
No, it is, because I'm just trying to, just as a threshold matter, if a court decides it has no jurisdiction, how does it grant any motion?
Right, I certainly think that's a fair point, and that the motion to strike was filed after final judgment had been entered. That's certainly correct. With that said, we think that regardless of the remedy, we still, for the reasons I've just articulated, have the right to bring the suit.
Could you address the city of Elsa point and why Heinrich doesn't eliminate that as an argument?
Well, Patel, of course, reaffirmed the city of Elsa and the city of Beaumont v. Bullion case. Heinrich, of course, was about Heinrich was about a private individual, and I think that was an ultra-virus cause of action in Heinrich. With that said, Patel expressly reaffirmed the city of Elsa. Patel was 2015. Heinrich is I think Heinrich is 2009, and it explained that although, of course, there's no such thing as an implied right of action for damages, Texas has no Bivens, Texas has no 42 U.S.C. 1983, you can bring an implied right of action on the basis of the Constitution itself for only, of course, equitable relief. But I also don't think the court really has to address that issue because, of course, the city officials are also proper defendants, most importantly, the executive director of the Harris County Public Health Authority. I do want to be sure to address the gift clauses point, the merits of the case, and we think that for largely the same reasons that the Texas Supreme Court articulated in In Re State, also known as the first Uplift Harris litigation, that there's still no sufficient controls. And what Uplift Harris held was there will be no public control over the funds after they are dispersed. And that's why half of the 6 controls that my friend on the other side discusses in his brief aren't relevant here at all. Controls like giving money to the third-party administrator in increments or determining eligibility criteria for who might receive the funds in the first place are wholly irrelevant.
Why doesn't the capacity to audit and potentially kick someone out of the program count?
Well, I think there's several important reasons for that, and that is that there are no audit procedures in place. There is no audit. The word audit is just a word in a contract, and I want to be sure to emphasize why that is. This is a 2 Reporters Record 67, and this was the trial court speaking to Mr. Maddox, who was Harris County Public Health's witness, and the trial court asked him, so let's say somebody goes to a car repair shop and spends the $500. You don't intend to restrict how somebody how a program participant spends the money. And he said, that's right. And the trial court said, meaning the allotment for the month. And he said, that's right. And then, and this is a 2 Reporters Record 82, Mr. Maddox was asked, well, how are you going to know if you need to kick somebody out of the program? Let's say they're using approved merchant category codes. He says, I think there's more planning to do in terms of identifying the specific mechanisms in which somebody is removed from the program. This is a 2 Reporters Record 83. Mr. Maddox was asked, well, let's say a transaction occurred at an approved vendor. how would the county remove someone from the program? He says, I don't have a specific example. We don't yet know what we don't yet know. I want to emphasize for the court, his testimony was, we don't yet know what we don't yet know. The word audit is a word in a contract. There's nothing behind the word audit.
Would there be any provision, say it's the last payment and someone decides to, you know, buy lottery tickets with it or something, like at the point that it's the very last payment, is there a what happens if the program's over and you can't kick someone out of it anymore?
If I understand the court's question to be asking, is the control only for the last payment, or is the control?
Or, no, I'm just curious, is there anything in the record saying, you know, there's this provision, and let's say it is a control that you could kick someone out of the program, but say it's the last payment and the program is ending, they're going to be out of the program either way. At that point, is there anything in the record that there's some control beyond potentially being kicked out of something that's already over for that last payment?
I don't think so, and I think that's certainly an important point for the state, because it seems that what they're saying is, well, we could kick somebody out of the program, but they don't have any procedure in place for how they think they're going to do that. And they also, maybe this also goes to the court's question, is there's been a lot of discussion about the contract, the attestation form, and that says, well, we'll make somebody sign a contract that says I consent to providing necessary documentation if requested. And then, this is at 2 Reporters Record 93, Maddox was asked, well, what documents would you require? And I think this goes to the court's question of what, maybe if the program is over, what happens? And Maddox says he didn't know. He says not at the moment, but that they were still working on that. So it appears that there's really not any procedures in place for how this actual program, how this audit process would work. I also want to be sure to point a little bit out about one of the changes that they've made since Uplift Harris, and that is the use of merchant category codes. What I'm referencing is 6 Reporters Record, pages 11 through 13. And Harris County has taken the position that, well, our debit card that we're going to give the program recipients is only going to work at places with approved merchant category codes. Those are written at such a high level of generality that they have almost no value at all. They say discount store, variety store, drugstore, pharmacy, gas station. And they're saying, well, in their contract, they say the program is restricted to the merchant category codes. That's Walmart, that's CVS, that's Walgreens, that's any gas station.
Isn't that some degree of control, though? I mean, it doesn't have to be a perfectly regulated system, right, in order to pass muster, or does it?
Sure, but under these facts, I don't understand my friend on the other side to be arguing that all of the products that one can purchase at any of those places would fulfill their public purpose. And what the Texas Supreme Court held in Ray State was 2 important things. Controls have to be enforceable, and they have to be good enough to where we can see if they're fulfilling their public purpose. I don't think Harris County believes that their public purpose is any product that can be purchased at those stores. That would include alcohol, cigarettes, chewing tobacco, lottery tickets, and I don't understand them to be arguing that that is fulfilling a public purpose of poverty relief. And as long as we're on the point about the merchant category codes, I want to dispel the myth that this is not like the TANF program. This is not like the SNAP program, and they say that they've modeled it after those things. That's not true. Those programs are administered via something called the Lone Star Card that's issued by HHSC. The court might have seen signs at places like HEB that says Lone Star Card accepted there. As Maddox explained in his testimony at the trial court, those are programs in which vendors like HEB opt into them, and they have a list of approved items, what are called SKU numbers, stock keeping unit numbers, to where the Lone Star Card won't work at the register if somebody isn't using a list of approved items. So that's the difference between how that program works and how the use of merchant category codes in this program.
But there's nothing in the Constitution that says you specifically have to have that set up, right, in order for your program to be
No, there's nothing that says you must always do it the way the state does it,
Right.
but you have to, the point I want to make is that this is not the TANF or the SNAP program. I think the answer to the court's question is you have to know if the controls are enforceable. The Texas Supreme Court says they have to be enforceable, and they have to be enough to where you can actually see if you're achieving your public purpose. And we don't think that these controls here are enforceable because they don't seem to have any teeth behind them. or if they're actually achieving their public purpose. And I see I'm almost out of time, so the last point that I want to be sure to make is that this case is pending before this court right now, and there's also a case called the original Uplift Harris case. And Harris County has an obligation, for as long as they submit to this court's jurisdiction, to confirm the presence of jurisdiction. They repeatedly told the Texas Supreme Court and this court that they had to commit these funds by December 31st, 2024, quote, or lose them forever. That was what they told the Texas Supreme Court, and I'm hoping that we can get some clarity as to which program they've committed those funds to. Thank you.
Thank you, Mr. Mendelson. Mr. Martinez. Can you answer the last question first? Are the funds gone, or are they still there?
Your Honor, they're still there. After we made those assertions, we've done further analysis and identified a separate set of funds that are not subject to those same restrictions. So we are still interested in pursuing either the Uplift Harris program or the Community Prosperity program, which it's going to come down to sort of what courts rule.
And is there any other deadline now that we know that December 31st, 2024 doesn't apply?
There's none from federal law. The Commissioner's Court is eager to put this money to good use, and so if we don't get a decision sometime soon, then we'll you know, they'll be considering whether to move on.
We'll do our best.
Thank you, Your Honor. Can I just say that the simplest, cleanest, and quickest way to resolve this appeal is to affirm on the basis of the Attorney General's lack of authority to represent the state in the district court in this case. That conclusion is supported by the text of the Constitution, numerous Supreme Court decisions, the Attorney General's own briefing in the Longoria case, and even the evolution of the constitutional text and the ethos that was driving the 1876 Constitution. So I'll start, as I think I should, with the text. The text of the Constitution says the county attorneys shall represent the state in all cases in the district and inferior courts in their respective counties. So that's my bedrock. And the question is, you know, what are the exceptions to that rule?
Well, I want to push back just a little bit. So is it your position that the Attorney General has no powers at common law that are relevant here? We're only limited to that statute itself?
It's that the Attorney Generals can only exercise powers prescribed by the Constitution and statutes. He does not have any common law authority beyond that, and case after case after case from the Supreme Court has said that.
So, but in Yet, which Hollins relied on pretty heavily for its judicial dicta, which we have to follow. We don't write on a blank slate here. We have to follow that if it's not clearly erroneous. And Yet cited a host of cases recognizing pretty broad powers of the Attorney General at common law that have even been recognized for state attorney generals at the U.S. Supreme Court. There's a Fifth Circuit decision, I think from 1976, talking about you know, these broad baseline powers, and that, you know, states typically, if they're going to take away those powers, they're going to do it expressly. So do we just chuck all that, or are we not in common law era anymore? Because we do have Civil Practice and Remedies Code 5.001, which makes common law law. So what do we do with that?
Sure. Well, let's talk about that statute.
Okay.
That statute says it's not just adopting the common law for all purposes of how we run our government. The statute is specific. It says the rule of decision in this state consists of those portions of the common law of England that are not.
That doesn't conflict, right?
What's that?
That's not in conflict.
Right, and I view the statute as addressing the rules of decision for how courts decide cases, right? If there's two stacks of hay next to each other and, you know, a guy subjectively doesn't think they're going to catch on fire, like, is that negligence, right? That's different from what powers and duties government officials have, right? We have a written constitution that specifies those powers in significant detail, and the Supreme Court has repeatedly said that the Attorney General does not have power beyond the Constitution and the statutes. On the Yet point, first of all, the state didn't really press yet as a basis for its common law authority in its opening brief, and so we didn't really respond to that.
But we can't ignore, like, a Texas Supreme Court case that's been on the books for 100 years, right? Nearly.
Well, so I would say that after Yet was decided, the key cases are Harney and Garcia, right? In Harney, the Court of Appeals rejected the notion of implied or common law powers of the Attorney General. The quote is, "As the powers and duties of the Attorney General are prescribed by the Constitution and statutes, those powers must be limited to those so prescribed and may not be enlarged by the courts." Okay? So that's what the Court of Appeals said, and then Garcia is a Supreme Court case from 1955 that says, that expressly approved Harney. It said Harney was correctly decided. We didn't take the case, but if it had been incorrect, we would have taken the case.
But is that a case where there was a suit to try to compel local officials to comply with state law, or?
It was a suit in both Harney and Garcia to remove county officials pursuant to provisions of the Constitution. Harney held that because there was no statute or constitutional provision authorizing the Attorney General to bring suit on behalf of the state in the trial court, the Attorney General lacked that authority.
So what do we do with Hollins then?
Hollins is a nullity here, right? The Attorney General's opening brief recognized that this issue was not raised in the Hollins case. It was not raised, it was not discussed, it was not considered, and it certainly was not adjudicated, right? The words Attorney General do not appear anywhere in the Hollins case. So it was not adjudicating the Attorney General's authority to represent the state. The Hollins case was addressing the state's, whether or not the state has an ultra vires claim against local officials, and whether or not an ultra vires act is automatically sort of irreparable harm to the state. It was not addressing who gets to represent the state.
But the Attorney General was the attorney in that suit, right?
Yes.
Right. Okay.
Right, but the issue, this issue of who gets to represent the state was just not addressed. I looked at the briefing yesterday. Oh, sorry, Mr. Chief Justice.
No, but the UDJA impliedly is a statute that creates a cause of action where you have to join the Attorney General to address the validity of a statute or ordinance. We're addressing an ordinance, and whether the ordinance adopted by Harris County Commissioner Court is valid, and so the Attorney General's got to be a party because the CPRC says so, right?
Well, Your Honor, they have never pressed that argument. You know, in the trial court where they had the burden to show their authority, they said, we have no statute. Okay, so set aside that they didn't meet their burden.
They can't waive that. They can't. I mean, the waiver of immunity is up to the legislature. They may say that when they get sued and appear, and don't want to appear, but I just don't see how that's it's an odd thing, but it's I guess one could argue, well, there's a difference between immunity and motion to show authority, but and of course this is what this court was created to do: issues where the validity of a statute or ordinance, and our jurisdictional statute says, and the Attorney General is a party. Now, it is an odd thing that the Attorney General, in many circumstances, as in Ray Schmidt's about, class actions, where the Attorney General files a class action against an insurance company, and they are both attorney and party, and it's apparent they can do that. Nothing in the legislature says they can't do it, so I'm not sure the distinction between a party and being an attorney for a party, if what we're talking about is the validity of a statute, who else can we get? I mean, the county attorney is not going to sue the county commissioners a taxpayer's not going to be allowed to, because they're not going to have taxpayer standing. if anybody is going to challenge this under the state constitution, it has to be the Attorney General. That's why we imply that waiver in the Civil Practice and Remedies Code.
So that was a lot.
It's
If
a
I could-
mouthful,
Yeah,
I know,
so
I know.
So just sticking with the UDGA point that you originally brought up, it's because they didn't press this, I haven't reviewed it recently, but my recollection is that it applies to municipal ordinances. And of course, the county is not a municipality. So I query,
Yeah,
does that even apply
I'm
to a
not,
county?
I'm not trying to trick you. And
No, I know.
you know, these are big questions, and we're being asked to decide them all for the first time. So things occur to us that may not occur to you. Please feel free to give us a letter brief, not a big, long brief, but a letter brief saying this is the answer to that.
Sure, and whether or not, I don't know that the UDJA says that the Attorney General, when so joined, represents the state. And I think that's really the critical question.
It says they've got a right to be heard, must be served with a copy of the proceeding, and is entitled to be heard. And says, well, so that doesn't make them a party. It certainly, you know, I mean, why are they entitled to be heard? They have a justiciable interest. And the courts use that as a basis for saying sometimes yes, sometimes no, that, you know, what is the doctrine of virtual representation is going to apply because they've got a right to be heard and all, you know, I mean, this is a complicated area that we got to sort through a bunch of different cases that, as you say, haven't exactly answered our question.
Well, I think that that the Harney and Garcia case have come as close as possible to answering your question.
But back, so again, my concern is the railroad question.
Yeah.
You know, a county commissioner's court and the county attorney wants to please them. And so the county commissioner's court do something, forget about our case, do something that is clearly barred by state law. This, you can't do it. Doesn't have to be the Texas Constitution, the general law. And the county attorney is not going to challenge that. District attorney does criminal cases, they're not going to challenge it. No taxpayer can challenge it. Is this just a oversight in the Texas Constitution? I'll agree with you, the Constitution says, you know, Attorney General appears in Court of Appeals by statute and the Supreme Court, it's a matter of Constitution. It doesn't say anything about district courts. And unless we have a statute like the UDJA or something else like that, they can't just show up in district court. So do we write an opinion throwing up our hands and saying, this is just awful, but counties can do whatever they want?
I do think that the Attorney General's limited authority in the district courts is a feature and not a bug. Going from the 1869 Constitution to the 1876 Constitution, the people of Texas deliberately reduced the Attorney General's control over things that are happening in the trial courts.
They didn't like those people in Austin, I got that.
Yeah.
Still don't to some degree, but that's a
Sure.
different question.
Well, and I don't know that I agree that there's no one who could do this. The legislature could pass a statute that allows the Attorney General to come into court and represent the state. The rest of the provision on the county attorneys says that the legislature can regulate the duties between the county attorney and the district attorney. So the legislature could also pass a statute that says if the county attorney is conflicted or unwilling to represent the state, the district attorney could come in and do it. And there are going to be some instances in which a party affected by county action will have standing to challenge that with an ultra vires suit. So it's not that there's no remedy. And really, ultimately, the people are sovereign, right? If county officials are regularly violating the law, the people can vote them out. This is pretty similar to the Harney and Garcia cases, where the question was who gets to represent the state, or not really who gets to, but does the Attorney General get to represent the state in district court for the removal of county officials? And the Harney case said, no, there's no statute, there's no constitutional provision that allows him to do it, so he does not have that authority because it's not in a statute and it's not in the Constitution. And it's the county attorney's responsibility to do that. And you might have the exact same, question, like, well, when is the county attorney going to want to remove from office county officials? I mean, Ms. Garcia was a county commissioner, right? This idea of common law powers, I want to get back to that, and Yet versus Cook. So I think Harney and Garcia are later cases that reject that. They say that it's limited to the Constitution and to statutes, and it can't be enlarged by courts by recognizing some vague, inherent common law power. The Hill case is great for me. It's Hill versus Lower Colorado River Authority. And in that case, they were addressing this issue of the Attorney General's common law power. And in 1978, here's the quote from that case. The Attorney General concedes that the recognition of common law authority believed to be found in the cases just reviewed, which included Yet, is interrupted by 3 cases. And it's Garcia, Harney, and a third case from El Paso. And the Hill case looks at all of that and concludes that the Attorney General only derives power from the Constitution and from statutes. And then that principle has been reiterated again and again and again. In Perry versus Del Rio, the Supreme Court said the Attorney General can only act within the limits of the Texas Constitution and statutes, and courts cannot enlarge the Attorney General's powers. What did Perry Del Rio versus Del Rio cite for that? It cited Harney and Garcia. Chief Justice Brister in City of Galveston said the same exact thing, and he cited Perry versus Del Rio, and he cited the Day Land and Cattle case from 1887, which is exactly what I'm saying here. We have a written constitution that specifies the powers of government officials in great detail, and government officials should not exercise power that is not mentioned in positive law, right, in the Constitution and statutes.
So you would have us write an opinion saying there are no more Attorney General common law powers under in Texas, right? That's what our opinion would need to say.
Right, that unless there is a statute that authorizes the Attorney General to represent the state in the district court on ultra vires claims, he does not have that power. Now, there's a limited category of cases dealing with private charters of private corporations, as you guys just heard, as the court just heard.
Could we also get to the control point before you finish your time?
Yes,
Yeah.
Thank you, Justice Ferris. So we've got 6 controls, and we discussed a variety of them, but the new controls that we have bring us a lot closer to Borgelt. In Borgelt, the Supreme Court addressed presumption after presumption after presumption that go in favor of the locality trying to do these programs. And one of them is a presumption that the parties to a contract will adhere to the terms of their contract. And our contract says that these funds will only be used for basic goods. Then we have audit rights. And my friend on the other side said, well, these are toothless and they're not fully developed. And that's because they sued on a facial challenge before we were done developing the program, right? So they're essentially bringing a facial challenge to this program and have to show that in no instance could we develop the audit rights in such a way that they would have the effect that's intended to make sure that the funds are being used for their purpose. We can ask for additional documentation, receipts to make sure that people are complying. Justice Ferris, I think you asked about, after the last one goes out. I mean, there are common law causes of action for breach of contract, right? So there are remedies to people not complying with the contract. But Borgelt says that people not complying with the contract is not a manifestation of the program. It's a breach, and not every breach of a contract is going to give rise to a constitutional violation. And essentially it says that if that were so, courts would become the full-time hall monitors of local government action. So, I mean, it's the state's burden to show that this set of controls collectively is not going to be sufficient. I'm happy to talk about any other aspects of the test, but we do receive return consideration in the form of information, and we do have clear public purposes. There's unrebutted testimony that shows what the public purposes were. I guess I would just conclude by saying that the text and numerous Supreme Court authorities support the conclusion that the Attorney General, without a statute, lacks the authority to represent the state in the district court in this case.
Thank you, Mr. Martinez.
Thank you. We ask you to affirm.
Did you all waive the UDJA?
We can't because it's jurisdictional. You can't waive a jurisdictional issue. Let's be very clear about that. This came up on a plea to the jurisdiction. Sovereign immunity is jurisdictional.
Seems unfair, but I agree that appears to be generally.
Let's be clear about what Garcia and Harney were about. They were about statutorily and constitutionally created causes of action. They were not about common law action. Let me read a passage from that. Since there's no constitutional or statutory provision which vests the Attorney General the power or makes it his duty for the removal of county officers under statute, the Attorney General cannot assert or exercise such power. That's always been the rule. When the legislature creates a cause of action, the legislature gets to decide who can bring it and who cannot bring it. That's always been the rule. But when we're talking about common law power, the question is, has the legislature repudiated it or not? Because of cases like Taylor and cases like Marino from the Texas Supreme Court, which say we have to have a clear statement to repeal the common law. I'm a little bit interested in what happened to the ARPA funds that have been at issue in this case for several years. We were told they had to be committed by December 31st, 2024. The county says they found some new funds. That doesn't quite answer what happened to the ARPA funds. Day, Land, and Cattle and Brady v. Brooks. Let's talk about those for just a minute. Day, Land, and Cattle says the court need not decide this exact issue here because the legislature passed a statute that did not grant the Attorney General affirmative power to bring a common law trespass to tri-title action, but rather retroactively ratified his act of using a common law power. That's how Brady v. Brooks interprets the Day, Land, and Cattle case. That's where we get the rule, where Brady v. Brooks says, if the legislature had the power to ratify an act, well, it probably also has the authority to give him causes of action affirmatively. That's what Day, Land, and Cattle is about. Hill, of course, is a case from the Austin Court of Appeals, so it doesn't bind this court. But more importantly, Hill is a case that held that the Attorney General can't sue a state agency, his own client. That's, I think, very significant here, because if the only way to reconcile Harris County's argument with Hollins is if the counties are supposed to sue their own clients for ultra-virus acts. It seems they're suggesting that the county attorney should sue Harris County officials rather than the Attorney General's office doing so. Otherwise, no one, or no government entity at the very least, could bring any lawsuit for ultra-virus acts. My friend on the other side brought up a point about the 1869 versus the 1876 Constitution and what the powers of the Attorney General are. And it's true, they repealed a provision that said the AG can superintend district attorneys. We're not attempting to superintend district attorneys here. We're using previously granted common law power. And I'm also afraid that their argument is a little bit inconsistent with the court's recent Webster decision, which explains that the Attorney General's office predates the Constitution of 1876 and was incorporated into the Constitution of 1876 and did not repeal any common law authority. My friend on the other side also brought up breach of contract cases. If the Attorney General's office has no common law authority, counties certainly don't either, unless they're granted by statute. I don't think a county could ever bring a breach of contract case other than the provision that we cited in our brief that says they may bring them for architectural and engineering services contracts. The other point that I would like to make in that similar vein is Harris County has sued the state repeatedly using the common law ultra-virus tool over the past several years. Perhaps the biggest example was Abbott v. Harris County, what became known as the mask mandate case. That was an ultra-virus suit. If the Attorney General has no common law authority, I'm very surprised to learn how Harris County brought that suit in the first place, because it too was a common law ultra-virus suit. And let's see if there's any other points. I think that is probably it. So unless the court has no further questions, we ask that the judgment be reversed and that judgment be rendered for the state.
I do have a question about this notion of a facial challenge when perhaps the program has not been fully developed at this point. How do you respond to, this may be appropriate as an as-applied challenge once, all the details are solidified, but at this juncture, on its face, there's just, too much that we don't know, and some of these problems could be fixed.
Well, I'll begin by noting that in the Uplift Harris case, the county argued that we had brought the case too late. And I'll also begin by noting that a problem we had in the Uplift Harris litigation was that the county testified in court what day they intended to make payments, and then decided to make the payments a day earlier when they discovered we were going to seek mandamus relief in the Texas Supreme Court. So as to, did we sue too early, I think that motivated the reasons why we brought that suit when we did.
But still, going to the notion of a facial challenge,
Sure.
That's a high bar to clear. And it's, we would be perhaps doing something for the first time.
I don't think so, Your Honor, because I think the court can hold that as this program exists right now, it violates the gift clauses. Perhaps Harris County will make a new program after that, and we'll have to determine if that new program complies with the gift clauses. But as the program exists right now, after a final judgment has been entered by a court, I think the court can say, as this program exists today, it violates the gift clauses, and I see my time has expired.
Thank you, Mr. Mendelson. Thank you for giving us another difficult case to work on. The marshal will adjourn the court.
All rise. 15 Court of Appeals now stands adjourned.
Racing.